around with the exception of Antarctica. It's probably the closest the number of us are getting, to be a rock star, but that's not very much further than that. But coming back down to earth, everyone, welcome to Singapore Convention Week, and in particular to this joint event that's organized by the Singapore International Commercial Court and the Society of Construction Law Singapore. And as you all know from the event title, what we are going to be discussing in the course of the next hour or so is some of the challenges in trying to deal with multi-party, multi-contract disputes with a specific focus on the SICC. And our panel will be discussing the challenges from, I think, what many of us will not be surprised to hear are increasingly complicated disputes that are coming up for resolution. Especially the impact of two words that you will see in the event title that we will be touching upon. And those are the challenges that are being posed by the issues around complexification and contextuality, and how the SICC is going to be responding to these challenges. We've set aside quite a lot of time at the end for questions. Those of you who came in earlier might have seen the slide which shows that this event is registered on an app called Slido. Those of you who are familiar with that app will know that it's a free and fairly convenient platform to use for questions. And we've got that up on screen, so you can download the app, and if you've got the app, all you need to do is actually just to enter the event registration code. And you see that up on screen, 78123339. And you can start posing questions as we go along. And I will pick that up as we go along. And if you like a question that anybody else is posing, please do use the icon, because what the system does is put up right to the very top the more popular questions. Right? And I will pose that to the tribunal in the order of the most popular ones. So if you see something that concerns you and you want to have it addressed as well, please do like it, and we will pick that up as we go along. My name is Mohan Pillai. I'm going to be your moderator for the session, but I am fairly certain you didn't come here to hear my dulcet tones. The real rock stars are going to be our panel. A number of them, frankly, don't need any introduction, but I'm sure you'll agree with me that they're all thoroughly deserving of one. So I will start with Justice Philip Jeyaretnam to my right. And Justice Jeyaretnam has deep connections, in fact, with both of the joint hosts of this event. He's the president of the SICC and was also the founding chairperson of the Society of Construction Law in 2002. And prior to his elevation at the bench, he was a highly regarded senior counsel acting in many large value commercial litigation, arbitration, and construction disputes. So he's very well placed, I think, to speak to us on both sides, as it were, of the bench, appearing before the bench and sitting now on the bench. So I think we will get some really interesting insights. Annalise Day is King's Counsel, and she is a leading English barrister experienced in complex commercial construction disputes. And I think, interestingly, from our perspective, both as counsel and arbitrator. So again, she will bring a perspective of not only dealing with these cases in terms of advancing arguments, but also trying to resolve them when you're sitting as arbitrator. And her practice has taken her to Asia, the Middle East, US, Europe, and she has experience of international courts, including the international courts at the DIFC as well as the SICC. And to my extreme left, Dinesh Dhillon, co-head of Allen and Gladhill's international arbitration practice. He has deep experience of international arbitration as well as litigation. He's appointed regularly as lead counsel across a broad spectrum of cases, including shareholder, telecoms, construction disputes, frequently leading on these cases in the Singapore High Court, the Court of Appeal, and as I'm sure Justice Jeyaretnam will attest to, regularly before the SICC as well. And to my immediate left is William Chung, Head of Legal at Samsung C&T, a leading global EPC contractor. William heads a team that supports construction projects across the region here in the Asia Pacific. And in his in-house role, he has significant experience of dealing with many of the challenges that we're going to be talking about today, but really from the point of view of the ultimate end user. And he has experience across the full gamut of dispute resolution models, from court litigation to arbitration, right through to many ADR processes. And finally, Lawrence Wong, on my extreme right, Senior Director at SICC, with responsibility for business development. He will be a familiar face to a number of us, not least because he regularly engages corporate counsel, practitioners, and business leaders on SICC's unique proposition as an international court. And with that, I thought I would lead in a little bit more detail into what we're going to be talking about today. So this afternoon, we're going to be focusing on some of the important aspects of trying to deal with multi-party, multi-contract disputes. In particular, we're going to be taking a look at some of the challenges that arise from complex disputes and really the extent to which our current dispute resolution processes can realistically cope with some of these challenges. We're going to be taking a look in particular at how SICC is responding to these demands. And we will then be able to turn to my colleagues on the left here and actually ask what the user experience is like when dealing with some of these initiatives, both here and abroad. But we kick off the session with an examination of the two key concepts that you see in the title for the event: complexification and contextuality. What do they mean, and how do they impact dispute resolution? And you'll forgive my glee as I turn to the judge, because it's not very often that a lawyer gets to pose questions to a sitting judge. So with that, I'm going to invite Justice Jeyaratnam to address us on the question relating to these concepts and what impact they are having. Judge.
Well, thank you. Thank you very much, Mohan. And it's good to see all of you, as well as to, well, can't see you, but know that we are being also observed online by, I think, already 50 people from, as Mohan has said, all the different continents of the world. So this afternoon, I thought I would just kick off our discussion with a quick exploration of those two concepts, which were, and the terms really come from some of the speeches that Chief Justice Sundaresh Menon has made over the years, and in particular his 2021 Goff lecture, and earlier this year a speech that he gave to the International Academy of Construction Lawyers when he focused on construction disputes. And those twin concepts, one is complexification, the idea that the world is becoming more and more complex, and as a result, and perhaps even more than the world generally, the way in which disputes are handled has become more and more complex, and how do we respond to that? And the second concept of contextuality, the importance of adapting procedures to fit the context of particular groups of disputes, establishing templates and procedures that fit particular categories of disputes, as well as the kind of case management approaches that deal with individual cases within those categories. And of course, I'll talk about it mostly in the context of construction. And the importance of those two concepts is precisely because what we have done in the SICC responds to those, to the challenge of complexification, and works off this idea of contextuality. It's informed the design particularly of our TIC list, which I think in due course Lawrence will give a little bit more detail on. But let me just situate it a bit further. I mean, construction, as many of you know, it's a complex exercise. It involves numerous skills and trades which have to be coordinated in time and space. And traditionally, this coordination has been achieved by breaking tasks down into linear paths for each trade to follow, and meshing those together in a plan, and then the contracts that govern the carrying out of those tasks are bilateral. There'll be a main contractor or a project manager who contracts with each individual participant, and because they are bilateral contracts, this results in bilateral disputes, one contracting party against another. More recently, we've seen the rise of collaborative contracting, a response to perceived misalignment of incentives within a traditionally organized construction project. And among the hallmarks of collaborative contracting, and again, it may be quite familiar to most of you, is some form of multilateral contract with elements of partnership or joint venturing, references to the use of best endeavors, references to good faith, and the adoption of mechanisms for profit and loss sharing of some kind among the participants, so that different participants are incentivized to help save costs for others and not merely look after their own interests along their own linear path through the project. But even without bringing into consideration collaborative multilateral contracting, even in the context of traditional contracting, the mapping of bilateral contracts onto the performance of a project, it doesn't eliminate the interplay of all those different skills and trades in the real world. And almost every construction dispute you will hear one of the parties talking about what a non-party has done that has interfered with its work, which has caused some delay or disruption, and how that therefore amounts to some kind of excuse for itself. But that broader context is very hard to bring into the bilateral dispute, especially when that bilateral dispute is taking place in what has become the preferred form of, or at least until recently, the preferred form of dispute resolution for construction disputes, which is arbitration. And now that organizational complexity, let me just quickly mention two other sources of complexity in addition to this that I've just outlined. The second is technical complexity, and buildings have become vastly more complex. The number of standards has mushroomed. We now have, for example, environmental standards, buildings having to include organic spaces. Plants have to be, integrated into the buildings. That's a whole new additional bit of complexity in the building, in how buildings are constructed. And then other services, the whole realm of connectivity and so forth, has added complexity to buildings. The third complexity is how projects are undertaken amidst a cacophony of recorded communications. I'm not suggesting people talk more than they used to. I'm sure they talked just as much on a medieval building site as they do today. But whereas in the past, when you look backwards at a building project, you would only see the minutes taken once a week of meetings. You would see monthly progress reports, a couple of pages with maybe a photograph or two, and you would see perhaps some daily records of specific activities during, concreting, one or two other critical activities. Today, every moment there will be not just emails, but direct communications on messaging platforms. People are taking videos and photographs all the time, and so any activity, but all the more so a construction project, is now surrounded by this thicket of evidence, but it literally is the case that it's very hard then to see the wood for the trees. So how do we deal with that? How do we respond to that? It's reached a stage where it goes beyond the ability of a decision maker to individually comprehend or make sense of all that has gone on. And so I think the ways in which we have approached it in the SICC is to consider what are the types of process and procedure which construction participants would find helpful in the way in which the project is then taken through the dispute resolution process. And in addition to that, the importance of being able to bring into the dispute multiple parties, because there will be situations where there are liabilities, indemnities, and it may be necessary. It may be helpful to have all of those resolved within the same process. So, in terms of the process itself, and as I said, we'll talk about it a little bit more later. The TIC list, which focuses on technology-related disputes related to infrastructure and construction projects. And we've added on additional case management features that are suited to the expeditious resolution of technically complex disputes. And we give the judges considerable powers to work together with counsel in order to manage, for example, one of the critical aspects, which is expert evidence and how expert evidence is dealt with, how to ensure that it doesn't get out of hand, that the judge leads the control of what expert evidence is to be introduced and how it is to be introduced and brought before the court. And of course, one of the things which we are looking at is how, over the next few years, and it's sounds like a bogeyman, but AI can help in the as a tool in relation to the management and analysis of this huge thicket of electronic communications that you see. And I think we've also got a number of protocols, which again I think Lawrence will talk a little bit more. Perhaps I can then just say a few words about collaboration in resolving complex construction disputes and how we accommodate that. First of all, we promote collaboration by encouraging parties to engage in early dispute resolution processes, including mediation, conciliation, neutral evaluation, as ways in which a very large dispute which covers multiple issues can perhaps be managed and reduced to those few which actually need to go through to a full-scale determination in the sort of set-piece battle of a trial. Defect claims, for example, are often amenable to being dealt with in either by mediation or some form of evaluation. And even in relation to, say, a discrete issue like that, it may be useful to break up the other issues, deal with a contractual interpretation issue which may bear on what counts as a defect for the purposes of this contract. So the judge may give his interpretation of that issue before that aspect of the case goes off into mediation, with a result coming back to the judge. Then we do adopt I suppose, a problem-solving approach to dispute resolution. I mean, if you read our Chief Justice's speeches, you will know that we do, without hesitation, we have moved towards words like users. There are users of a court, that the court is providing services. And so that entails a kind of change of mindset and how we approach things. And then beyond that the courts are there to help parties ultimately solve problems. It's not just about questions of right and wrong. I mean, those are important. That is a core function of any court. But beyond that is problem solving. And we see that in many areas. If you look at Singapore's family justice system, so I'm straying a little bit, but where the key value is therapeutic justice. You see how a traditional system of who's right and wrong has moved completely away from that towards what is it that helps parties to solve the problems that they have in a context where we work together with other agencies as well. So those are some of the examples, and I think perhaps at that point I can, which introduces the topic. At that point, I hand it back to our chairman.
Thank you very much, Judge. Many Singaporeans have this preoccupation with what they call the 3 Cs, condominiums, cars, credit cards. But certainly from the judge's analysis of what we've just been discussing, the 3 Cs have just taken on new meanings: complexification, contextuality, and collaboration. And he mentioned the user, which is increasingly coming into focus in the way our courts are taking a look at how they should be dealing with these kinds of disputes. And I think we are very fortunate in having someone like William with us. It's not very often that you get the ultimate end user participating in a panel. And with someone like Samsung C&T, a global EPC contractor, I think we have the opportunity to get some really helpful insights into some of these concerns that the judge has just addressed. The extent to which these reflect practical, real-world concerns that Samsung has as a global EPC contractor.
Thank you, Mohan. Before I share about what the end user like us, a global contractor, experience in the real world, I want to say a word of appreciation because for us, multi-party, multi-contract disputes is always a headache for us. It's a big concern for us. But when you read CJ's speech in 2023, as well as the golf lecture, we are appreciative that adjudicating body like SICC is actually also looking at all these challenges that the industry players face out there. And what I'm going to do is, if I can, I'll actually share some possible real-life instances, but the twin challenges of complexification and contextuality is present, is very real. We encountered it a lot. First, on complexification. And I think Judge mentioned the 2 aspects of it. It can be in the form of technical complexity, and sometimes the other aspect, evidential complexity. Now, technical complexity, we can see it happening, or the trend is that you're going to have accelerated adoption of new technologies in construction. Different from IT or fintech, construction innovations are usually incremental. But if you look at the trend all over the world, you're having mega projects. We already have that. And now in the Middle East, in Saudi, you're having giga projects. You have projects like the NEOM, the Cube, and there are very innovative technological advances there, being deployed there. And then there is, very soon, we will have to deal with decarbonization, and that will have a knockdown effect on how construction are undertaken in the future. Even materials. Granite are no longer be just granite. It will have to be low carbon granite, zero carbon granite, sometimes even carbon negative granite. Now, why would this be a problem for contractors in construction disputes? You see, in dispute, it is at the end of the day a forensic exercise. You're really trying to find out facts, and when you try to understand the issue at a granular level, you will get into difficulties, and the challenge is sometimes you have legal issues of causation. But let's say we take a very common construction activity like piling. Piling in the future will be different. You now have hollow piling, vacuum piling, and sometimes when adjudicator, let's say analyst as an arbitrator, has to determine, causation issues. There are high difficulties sometimes just to begin to understand the issues at play. So all this challenge of technical complexity, they are not hypothetical, they are real. What is definitely felt and very much present is evidential complexity. In my role, I have to sometimes support disputes or sometimes just conflicts that are leading to disputes. And what we are seeing now is, I remember there used to be a time when sometimes a dispute is referred to us, and I find myself having to go through maybe 3 or 4 ARCH files. But now, evidentially, first, when you're trying to understand a dispute, you're looking at digital evidence. And the ease of reducing records, sometimes communications. Just now, Judge mentioned about communication. And I can share with you, nowadays in disputes, more often than not, I see WhatsApp messages being used as evidence. Now, what happens is there's now an explosion in terms of the volume of evidence that parties and then advocates and finally the adjudicator need to contend with. And it is a challenge. Well, for me personally, sometimes it is very hard for me internally within the organization to properly advise my internal stakeholders how to proceed, mainly because it just takes that much longer time to go through the evidence. Contextuality is also a very real challenge for us. Why do I say that? We've just mentioned about the two aspects of complexity. Yeah? Now, we are very used to categorizing things. Whenever disputes come to us, we tend to think, okay, what has worked conventionally will work or continue to work. But sometimes, taking evidential complexity as an example, you'll find that the norms that we've been working with may not actually lead you to efficient disposal of a dispute. So contextuality that is the challenge with contextuality. Do we relook at how we resolve disputes? Is the current set of norms or procedures that we have sufficient? Is it really fit for purpose? So these twin challenges of complexification and contextuality, I must say, I can attest, they are real. They're not hypothetical exercises. And the third C, Mohan said, is collaboration. The final thing I want to say is, for the industry players, we need to think about collaboration. We cannot overlook the relationship dimension of contracting parties. In infrastructure projects especially, international infrastructure projects, it is really an assembly of very different disciplines, engineers, designers, vendors, suppliers, material specialists, and it is actually assumed, a given, that there should be cooperation. And whenever dispute arises, it is already a problem. But when you add in these twin challenges of complexification and contextuality, it can really strain working relationships. And that's always a big concern for us in Samsung. We know that there will be disputes, but how best to efficiently deal with it, obtain adjudication, and still preserve that working relationship. if I can draw an analogy, if imagine yourself, you're in the rowing in a boat team of eight-man crew with a coxswain, and you are the coxswain. If any two rowers are having a bit of a tiff, for sure you are in a race, and infrastructure projects are in the competition with time. Your boat will not reach the finish line in time. So that relationship aspect is actually very important. Yes.
Thank you. I mean, I put myself here between the ultimate end user and the court. Of course, the parties that generally happen to be right there in between the council. So I thought it might be really helpful to turn to Dinesh and Annalise and just get a sense from them as to what their professional experience have been about some of the concerns that we've heard expressed. And interestingly enough, it's quite clear from what you've heard from William that these are real concerns, that ultimate end users are grappling with some of these issues, but it's council that usually ends up dealing with the pointed end of it. So if I can just invite Dinesh and Annalise, perhaps briefly before we move on, to touch on exactly how the SICC is responding to this, perhaps at a high level, what your professional experience have been and how you've seen these issues being dealt with here and elsewhere. Annalise, would you like to start off?
Not a lot of collaboration, not a lot of love. Let's be real. The way a construction project normally goes is everyone marches up to the barricades with their weapons, fights quite hard and see who falls over first. I mean, that is the traditional way. And obviously when you've got lots and lots of different parties involved, it can be incredibly difficult. Second major problem are experts. And the suggestion that they should be neutral and independent, I'm afraid too often doesn't prove to be the case. Sir Robert Aikenhead likes to tell this story about garbage in, garbage out when it comes to delay experts, which is very unfair, but the importance of having the issues defined and of people addressing the same points and of ensuring that the points that are really in dispute are those in dispute. How many of you have read joint statements that agree absolutely nothing and simply add to the complexification? And I think courts in particular, but also arbitrators, and obviously here you have Doug Jones who's sort of leading the way on this in a very important way, saying to the arbitration community as well as courts, because I think courts traditionally have been better at this, we will call out experts who are not acting independently, and we also want some direct access to the experts. Documents, what can I say? It's still amazing, though, how people manage to document things badly, but yes, the first thing we always ask for are the WhatsApp messages, and you know all the juicy content will still be on those. Witness statements, if I could just mention those, we've had some recent reforms in the UK that are actually working very well, where witnesses, shock horror, are only now allowed to actually give evidence of fact. So they're not allowed to sit there and recite the documents. Lawyers have to sign statements saying that the statements are in the witness's own words. And again, witnesses now tend to stick to what their statements say in a hearing. Also important. So yeah, I think there is a need crying out for good case management of these disputes to ultimately help and assist the parties to act collaboratively and to reward collaborative behaviour.
I agree with what Annalise has said. I think one of the great issues when it comes to a complex case, one that really requires context to be addressed early, is that if you're trying to fit it into the traditional dispute resolution model, the statement of claim, the whole process that we're used to, discovery, you can get a square peg in a round hole syndrome. You can get a situation where the whole process is one of indigestion. And you find that there's a tendency, especially when there's so many parties, all not wanting to lose out. What they will do is they will put all the issues in early. There's no early case management to deal with it. And it's only towards the end of the hearing, at the trial, that you see things sift away. 20-day trial can be cut down. You know, the actual issues start to be focused on, and that's all quite wasteful. And two examples that Annalise touched on that I agree with, particularly documents. Now, I was involved in a case before the SICC, the DISTAR dispute that generated quite a few decisions. it's a major shareholder case. It wasn't a construction case. But the documents in that dispute alone, the court described it as a deluge. And to put that in context, I asked one of my trainees, how do I let we were doing a talk in the firm to people to know about the case. How do I give a sense of the degree of documentation involved? So he came up with a novel idea. He put the map of Singapore on the screen. He did a calculation of the documents versus the kilometers, and we realized it covers the whole island. It literally would have covered the whole island. And if you were to not take the time to sift through that early, to really be core about it, and imagine it in a construction context, it's completely upside down in terms of case management. And the other aspect would be, and touching on documents again, it would be discovery. I think the traditional model of general discovery, if it's a complex dispute, it may not be very helpful, because sometimes you would end up in a situation where you might end up over-disclosing. You typically want to disclose everything relevant, but I have found at trial, very often, even in very complex disputes, it is a few documents, key documents, that decide the key issues. A lot of the rest of what is relevant or disclosable doesn't actually decide anything. And the last point is, again, experts. These are technical disputes, and I agree with a lot with what Annalise said. That is my experience too. If you don't decide what exactly the expert is going to decide early, when you have multiple parties, you could be talking at cross purposes. One expert says this is an issue. Then, because you're defensive, you bring an expert on an issue that you actually don't think is relevant at all, because it's not addressed early. And then very often you find that experts get straitjacketed. I often find this with the weaker parties with the weaker case. The expert will be given all sorts of assumptions to make that qualify his report. And by the time you get to trial, the report is very thick, but your cross-examination may only be, you made assumption A, B, C, D, E, hence you're not answering the real issues, and that's it. You've proven it's worthless. Why go through all that at trial when you could actually, front-load the system? So to close off on that, I think there's a last C that all this relates to, which probably concerns the clients a lot. It's called cost. So I think it makes a huge difference.
Yeah, thank you. Thank you, Dinesh. You almost get a picture of two teams of horses pulling in opposite directions. Lots of sound, lots of effort, lots of motion, but very little progress. And I think this is helpfully going to take us to the next point in our discussion about how to deal with these sorts of issues, and in particular, how the SICC is proposing to deal with these issues. And we're very fortunate to have Lawrence with us. He's going to spend a bit of time just drilling down into the details of how the SICC is proposing to confront some of these challenges. So with that, Lawrence, I'll hand over to you.
Thank you, Mohan. Well, I'm glad to say that after hearing from William, Annalise, and Dinesh, we do have some solutions to meet some of the issues that we brought up. But even before that, I guess a bit of a background. During the SICC symposium on Monday, we actually heard that infrastructure projects in ASEAN itself is at a level of $4 trillion US. So given that, and given the fact that you have all this going on, there's definitely bound to be lots of disputes arising, and infrastructure projects, as you know, is certainly going to be multi-party, multi-contract with lots of complexification. So the question is, how do we put order into contextuality? And that's where we're looking at it. I'm using slides because I always feel that it's always easier to connect. So as we set up the Technology, Infrastructure and Construction List, or the TIC list, as I would use, so as I won't keep stumbling over many words. Purpose design option for resolving international complex technology, infrastructure and commercial disputes, and involving technically complex issues or questions. So you have the two parts that we're talking about, not just evidential complexity, but also technical complexity. So in terms of the adjudicators that we used in the court, each case that's placed in the list will be managed and adjudicated by specialist TIC judges that's independently appointed by Chief Justice from a panel, featuring jurists from 5 different jurisdictions, each with special expertise in resolving such disputes. And in terms of how we do it, in terms of the process, so we actually offer several unique procedural features which make it particularly suited to addressing the unique evidential and legal challenges that arise in such large and technically complex infrastructure disputes, and ultimately resolving the dispute in a timely and cost-efficient manner. And I think you've heard Justice Jeyaretnam and also Dinesh refer to it earlier. The unique feature of the SICC is that we have very robust judge-led approach to case management. So that's something, for those of you who have appeared before the High Court in Singapore, that's something very different from the approach that you see in terms of pre-trial conferences in the High Court. And I would say that those who are more familiar with arbitration would actually find that this is very much more the experience that you get within arbitration. Now, what do we talk about when we talk about special procedural features and also the dispute resolution techniques that we have available within the SICC under TIC list? So, witness statements, analysts will talk about that. With the new SICC Rules 2021 that we introduced, yes, we've refined the definition of witness statements that come in, so it's very much like how analysts has talked about it, straight evidence of facts and nothing beyond that. So, the court has the powers relating to exchange of witness statements prior to document disclosure. This again is a very unique or refreshing new approach to how the procedure goes along with court. The second bullet point, I think, is one of the most important parts of having a complex multi-party, multi-contract dispute resolved, and that's the ability for the SICC to join relevant parties. If this is something that, notwithstanding perhaps objections from some of the parties, the court can still issue an order to join parties in. And that's something that, again, I would say that if you compare to, say, within arbitration, you would have issues with that in arbitration, because remember, there are two factors we met in any arbitration process to join the. One is that there must be consent of all parties involved, and number two, there must be prima facie connections between the parties to be joined. So a very simple thing like even your back-to-back arbitration clauses, but one of the parties has an arbitration clause for a different institution, that's it. The joinder process is not possible on that one. Third one again comes to management of expert evidence. We made it very clear within the court how experts may be appointed, and you need leave of court, and as far as possible we would want common experts, single common expert, and if not, then the court has to decide first. So there's no automatic appointment of experts. So we've addressed another point brought up by both Annalise and Dinesh on this one. And the use of Scott schedules for presentation of cases and submissions, something that's within the SICC, I would say, is relatively new, but I think within the dispute resolution community and for construction disputes, it is not there, but something that we've brought in, and again, within the ambit of the SICC, that's how we've always been seeing ourselves. What are international best practices that we can actually apply and adopt within the court? And so this is something that you see. And of course, the last bullet point here is the powers to facilitate recourse to alternative dispute resolution mechanisms. The key thing is, remember, contextuality that I started with. How do you tailor each dispute to ensure efficient resolution? And this one is something that within SICC we find it very important. Amicable dispute resolution is a key thing. Not everything has to go through a full hearing. So within the TIC list itself, how do we help use alternative dispute resolution mechanisms to contain or even downsize the whole dispute, especially of special relevance in the context of construction disputes, where maintenance of commercial relationship, which William stressed on, is often a key consideration in such dispute resolution. So those are the key procedural features and dispute resolution techniques. Now, the other thing that we've introduced within the TIC list are two optional protocols that parties can consider adopting. So this is not something that the court can order, but only with the agreement of the parties involved. The first one is the Simplified Adjudication Process Protocol. What this does is streamline resolution of the smaller value claims in cases containing a large number of distinct claims management of distinct claims and the management features are such. So when you have multi-contracts, you have obviously would have very different size of the claims, right? So do you need to go through every single one, or parties, if they are agreeable and adopt this protocol, then they will look at smaller value claims and see how we can move towards that. And here's where it gets a bit technical, and I really don't want to spend this time that Mohan has reminded me. I only got 10 minutes to try to go through the whole entire complexity. So the first part, as you can see down there, please, for the details on the forms and all that's required, is contained in Appendix E of Order 28 of the SICC rules, right? So all that's available online. I think if not, we have left several copies of Order 28 over here that actually outside on the table that actually contains the TIC list itself. But the appendices are not there, I apologize for that. So what does this seek to do? To provide cost-effective, simplified adjudication process for certain claims within the list. And there's two levels here. The next bullet point talks about proportionate recovery for what parties have agreed as the lower value excluded claims. So you have the entire claims down there. If you agree to come to this protocol, then parties will agree there are certain lower level claims that you exclude from the main claims. The court will still hear the main claims, and then after that, on agreement basis, parties will agree, say, after everything is decided on main claims, then everything left on the lower value excluded claims will be 30% of claim. So if parties are agreeable to that percentage or whatever percentages parties agree to, that will be done. The other one is, what do we do for the higher value excluded claims still? And with that, we have certain rules down there dealing with, say, agreed bundle of documents, use of Scott schedules, evidence, submissions, and determination. So all that is very clearly listed for the two different types of excluded claims on down here. And of course, the last bullet point, the main claim still carries on, claim or claims in that sense, right? So how do you reduce something with 15 different major points to say, at the end of the day, agreement on two main claims? The rest could be either through amicable dispute resolution by going to, say, the SIMC, since we're talking about international disputes here, for mediation, and then after that, creating the sets for lower value claim, excluded claims, and also the higher value excluded claims. The other optional protocol we're talking about is something that we call the pre-action protocol. Again, the aim of this is to encourage frank and early exchange of information between parties on their claims and responses. So it's not the usual process that you file your replies and then you start exchanging documents and what have you, but parties agree to come in. Your details here are found in Appendix D of the same Order 28. But what we aim to do is put parties in a position to make informed decisions about the possibility of settlement without recourse to litigation by having all the frank and early exchange of information. Hopefully that we can help achieve this. And also at the same time to support the efficient management proceedings where litigation is necessary if parties cannot agree to settlement on this. But note my wording down here, the protocol must not be used to secure an unfair advantage or to incur costs unnecessarily. And do remember, because we have very robust judge-led case management conferences, I'm sure Justice Gerard Nam, if sitting on it, will make sure that parties do not try this thing on. So with this one, the information can be found in Singapore statutes online, Order 28 and the various appendices, or come to our SICC website. Under a tab called Guide to the SICC, you will see the TIC list. Click through it. You obtain the various PDFs that will help you to give you the various appendices within the TIC list. So I don't really, as I said, I don't want to go into too much details on this, but to give you the idea of how we have done this to ensure the contextuality kicks into this and help reduce the complexification of objects. Just to give you a list of that, the fact that we actually have 15 particular judges on this list, of which 6 of them are international judges. Justice Gerard and I, being president of SICC, will definitely be on this. We have Lee Siew Kin, who was trained as an engineer before he became a lawyer, before becoming a judge, and then Justices Kumarasamy, Tan Seong Tai, Edith Abdullah, Vincent Hung, S. Mohan, Andre Anyam, Kwek Min Lak. But amongst our international judges, Patricia Bergin from the US and Doug Jones, which I think Annalise has referred to, and many of you in the construction arbitration field would have heard of him, together with Vivian Ramsey, of course, Beverly McLaughlin, the former Chief Justice of Canada, and Samuel Reyes, formerly from the Hong Kong courts, as well as Simon Tolley. And Simon Tolley was the judge who gave the judgment on the key cryptocurrency dispute that we had on Coin versus BCBG, I think. I keep remembering Coin only because it took me a while to remember or to figure out how to pronounce QUIONE. Okay, we do have model clauses, and again, this is on our website. So there are agreements. For agreements pertaining to TIC list, we have three different types down here. One is agreement to place a case. If you want to ensure that a particular contract at contract stage will go on to qualify for the TIC list. Of course, you can do it post-dispute, but again, to the transactionals in the room, I would basically say, do consider this if you are looking at a construction infrastructure or technology type issue. Agreement to apply the two voluntary protocols, because I think you know that most times once post-dispute, it's harder to get agreement. So if you want to consider doing either a pre-action protocol, the simplified adjudication process protocol, consider adopting the model clauses that we actually have on the website. Mohan, with that, and hope I'm not confused too many people down here, I hand it back to you. Thank you.
Thank you. Thank you. We'll judge that by the number of questions that come on the subject that you've been speaking on, Lawrence. We're starting to get questions coming in already, so perhaps it might be helpful to just remind those of you who have got Slido and are looking for the event code. It's 7812339. You know, there are a number of adjectives that come to mind when you think about some of the things that the SICC is going to do. I mean, almost certainly it's interesting. Some might suggest that a number of these initiatives are perhaps quite contrarian. Almost certainly, some of them are quite unconventional. You know, for example, the idea that witness statements should be put in before document disclosure takes place is certainly not what one commonly sees. And it might be interesting now to take a look at the user's perspective to see how it is that, you know, these sorts of initiatives might be perceived. So I'm going to turn to Annalise and Dinesh in particular, given their role as counsel on major complex projects, about how they view the impact of these measures, in particular in their role as counsel in managing these disputes when it comes to the stage where these arguments are being presented and these cases are being managed in court. And secondly, perhaps just taking a step back a little bit, how they see clients in terms of whether these initiatives are likely to be welcomed at their level.
Well, if I can start by offering a view between the pre-action protocol and the adjudication process, the experience in England has been that adjudication is far more effective in resulting in settlement of disputes. So I'll be interested to see what happens here. There are a number of reasons for that. A lot of clients say they actually want a decision. And obviously, in adjudication, you get a decision that's binding on an interim basis in England, but our TCC, our Specialist Construction Court, have made very clear that it will be enforced absent exceptional circumstances. And I think when you look at the statistics, it is that innovation which in and of itself has resulted in far larger settlement numbers, things never going to court. That doesn't mean people reach the settlement in accordance with the adjudication decision, but it often breaks that deadlock. And I've always thought something like early neutral evaluation is very underused. And again, whether that might be something to take advantage of in a court like the SICC. Obviously, I've mentioned Doug Jones, but Vivian Ramsey was absolutely instrumental in building up the TCC to have the respect and prominence along with the commercial court, which it didn't have before that. Another very effective tool that the TCC has used in England is something called Part 8. And that is a special procedure where you can have a point of law or a point of construction that's dealt with really through submission. You don't have any live evidence, you don't really have many documents, but say you've got a contractual clause and the parties can't agree what the meaning of that clause is, It's become enormously important and actually enormously used as a way of the parties going to court and within 2 or 3 months, again, having a decision, a final decision on that point of construction. So again, very much welcome the equivalent procedures that are being put in place here. The issue of ability to join relevant parties is, of course, a thorny one. The only court that I'm aware of is the DIFC, who've actually have a provision whereby you can join in a party without their consent. And this led actually to quite a debate between Mr. Justice Cook and Mr. Justice Giles, because Mr. Justice Giles decided in the DIFC, in a case I was involved in, it was an auditor's case, that the audit partner should be personally joined in. These parties all lived in Lebanon, not Dubai. And then he was overruled by Jeremy Cook, who said, yes, this person should be joined in because he needs to be joined in for the dispute to be resolved. And obviously, when one looks at construction disputes, and I know the SICC's had debates about this before, whether there should, at some stage, be a power, because at present, as far as I'm aware, most courts and most tribunals are powerless to force parties to join in. That's, again, a topic for discussion. Should there ever be circumstances in which joinder should be mandatory? Again, just to mention, within the UK, we're also looking at alternative procedures actually outside court. So again, looking at having something akin to, there's a platform being set up where you'll have your dispute, low-value dispute, determined purely on paper, which sounds a bit like what and then you get your decision, you can't appeal it, and that will be enforceable in the same way as an arbitration award is enforceable. Heard a lot from users that we just want a decision. We can't afford to take a low-value dispute and spend a lot of money on it, and actually the business just wants a decision on that. The other option they've come up with is the use of AI to decide those smaller value disputes. So we better come up with something or we'll find ourselves replaced by machines.
Thanks. I'm quite excited at the prospects of how the pre-action protocol can focus us as counsel to help the clients, really, because you get this opportunity, and in the SICC context, it's before the judges who would potentially be hearing the actual dispute, to help to categorize and where the dispute could actually be resolved. So the collaboration approach of perhaps this aspect could go to mediation, this aspect could go to the simplified track, helps to separate the wheat from the chaff, so to speak, and takes away, I think, that frustration I shared earlier, which is everything gets backloaded to the trial, and you're just, making more of the dispute that you should. And related to that, I think, is how would the clients receive it? I think that in the context of a multi-party contractual dispute involving big projects, very often I've been involved in disputes, both in arbitration and litigation, where that first dispute is only one small piece of a project that's ongoing. It's going to be going on for years. It could be line one of a big railway project. Now, if your dispute processes are not efficient and not helping to keep the relationships between the parties, it ends up being counterproductive, because all that can potentially spill over, I think, in real terms, to affect the long-term relationship and the long-term viability even of other things that just generates more unnecessary disputes. So I think that on the whole, that knock-on effect is kept away. The clients can focus on what's really commercial in the dispute, what's really affecting, needs to be resolved so that the project goes on. It's truly dispute resolution to preserve a relationship.
Thank you, Dinesh. Quite interesting ideas. I mean, certainly from where other courts confronted with these kinds of issues are coming up with early neutral evaluation, Part 8. And I'll turn to the judge and Lawrence in case they have any comments on that. But before I do that, I did want to ask William, in terms of the client's perspective on these, whether someone like Samsung, given their role as an EPC contractor, how does someone in William's position view these initiatives? Does he see this as being really helpful to the construction industry and something that the construction industry would be looking forward to and welcoming?
Well, the short answer is definitely a yes. And I think Dinesh touched on it. The client side always have this concern about cost, right? And if you have multi-party and sometimes different sets of advocates or experts, the cost multiplies. And I'll touch on two things. Pre-action protocol, actually, we find that is very useful. Because it sort of trains the parties into what really is at issue. It's not just about saving the client costs. Sometimes, at the end of the day, the client really want to have a just and fair outcome. But the pathway to getting to the outcome, we also need to consider whether we are not wasteful, for example, that we get all the things that there's really an issue at play ventilated up front. And then the education process can focus really on resolving the more key issues. And the other thing that has been useful and welcome is neutral evaluation. Mainly because contracting parties, these are seasoned professionals, and if they have conflicts or difference in opinions, it's very hard sometimes to short of getting someone neutral, completely independent. I've seen DAB boards and so on, because DAB is usually appointed by one of the parties. Sometimes that's also not so effective. But in our experience, we've employed neutral evaluation before.
Thank you. Thank you. Before I turn to the judge and Lawrence to see whether there are any comments on a number of these initiatives that other institutions are launching, I did want to come back to the protocols that Lawrence mentioned. And of course, one of the points that Lawrence highlighted, that these are voluntary protocols. What that means is that parties have to agree to the application of these protocols. And I did want to turn to Annalise and Dinesh to get a sense from them in terms of as counsel, whether they see these sorts of protocols being an attractive option for parties after the dispute has arisen, in terms of it being a viable approach, or do they think that these kinds of protocols really require some mandatory application because they may not fly unless parties agree to it pretty early on before the dispute should arise, for example, at the contract stage?
Yes, I mean, I think in England, the pre-action protocol is mandatory in the sense that you can be penalised in costs if you don't follow it. But the downside to it being mandatory is you see quite a lot of parties going through the process, but they don't mean it. It's a bit like saying parties have to mediate before they can commence proceedings. I'm afraid that people learn to play the system. And also there can be quite a lot of posturing to test the other party. Are they really going to issue? So I hear clients saying, well, I don't really pay much attention to that till they issue the claim. Now that's a failure of that system. It seemed to me that the SICC had thought about that. I think definitely having a judge involved would be incredibly helpful because it might give that authority, that ability to try and just broker something. We've had something in England called court settlement process, but that was after issue. So that meant you could ask for a TCC judge to mediate your dispute, which some of the judges felt slightly uncomfortable about. But I know that your judges are very skilled. Again, having experience of Vivian Ramsey, he acted as a mediator. At the end of the mediation, we hadn't settled. He said, up to you, but I could just give you a couple of pages of what I think. Parties agreed, dispute settled within a week. The parties were miles apart. So again, the importance of just having someone as a sense check and a guide, I think, can't be overemphasised. A bit like as your Lord Chief talked about, the Chief Justice has talked about learning lessons from family proceedings. Let's be real, emotions can come into it, and sometimes having a neutral party just to say, hey, calm down a minute, let's see if we can get this relationship back on track, or if it's going to end, to split it up in a more civilised way is really, really important and really insightful. And I think that link isn't something I've seen made in other jurisdictions. So I think it's very impressive that that link's been made here.
Thank you. Dinesh.
I'm not a fan of these multi-tiered clauses. I'll put up my hand and say that, because my experience has been that very often it does result in going through the motions. If one party wants to be difficult, they just are difficult anyway. The party that genuinely wants to benefit from it must have an interest in it and appreciate the benefit of the pre-action protocol. So I think that's why I think it's critical for counsel to understand the benefits of this so that they can impress it upon their client. And the key messaging must be how this protocol helps you in terms of managing your overall cost, your overall result, and ability to get a just result. And my own experience from the case management conference regime in the SICC, which I think might be reflective of what you could expect at a pre-action protocol to some extent, is that it's very robust. The judges come very prepared to actually engage you on which issues really matter, and which issues really should be considered relevant to the end result. So the clients tend to benefit. I think that's the key incentive to participate, and if anything, in the process, more than a mandatory clause.
But there's clearly a subtle hint in the pre-action protocol, because the court does have power to penalize parties in cause where their conduct has not been reasonable. So, I mean, I did say it was voluntary, but there is that whip that is effectively being held behind the back of the judge, who has the power to deal with parties who behave unreasonably. Well, thank you very much, both of you. I'm just wondering whether Judge or Lawrence, you have any comments on what you've heard thus far?
Well, there's been a wealth of suggestions and thoughts and analyses of, and indeed comparisons, and I think that's a very rich set of material. So the first point I wanted to make is that the attitude of our courts, not just the SICC, but our courts as a whole, is very much one that reform, change, innovation, these are part of what we do and what we think about. And so everything that's been said today is something that we will, we think about, and when we make changes, we do so in consultation with the bar, with users, and importantly, we also evaluate what has been done and where we are with particular practices, so that we try and establish some sort of feedback and evaluation of changes that are made, whether they really are effective. The second point I wanted to make, which is responding to one of the themes that came out, which is about dealing with low value claims, possibility of using AI and so forth. I think that's a little bit out of the remit specifically of the SICC, because almost by definition, the claims are going to be high value claims, where the key element in management is really the early case management, the early attention of the judge, who's going to be the final decision maker. But if we look at our court system more broadly, I think that is absolutely critical. A critical part of our access to justice is how low-value claims are dealt with. And so even within the construction industry, of course, there are many low-value claims, and how are those handled, which includes, but is not limited to, adjudication. Our courts, our state courts, have developed protocols to deal with low-value construction claims which do not fit within the adjudication process. But then I turn to adjudication. So adjudication, mentioned I think by Annalise in particular, it has been very important and reflects the concept of, I suppose, good enough justice. That's really what many businesses want, which is just let's get a good enough answer, and then perhaps we might tweak it a bit with the other party, come to some kind of settlement which tweaks it a bit, but it's gotten us 80% of where we want to go, and it brings things to an end at a much lower cost and much more quickly. So the point I wanted to make following on from that, which is where the potentially in the future the SICC may come in, is that adjudication is really a national thing. It's done within particular jurisdictions, and that leaves a gap for international construction projects, which is filled to some extent by things like creatures like dispute boards. But of course, dispute boards then have to be enforced by an arbitration award, and then in turn, because ultimately everything ends up in the courts, you have to then enforce the arbitration award in a court. And so there have been discussions internationally about the possibility of adjudication and how that can be enforced, perhaps directly by courts under a model law, and I think that's something which is very very interesting. And let's see where that goes. And I think if there were such a if we did get to that position, I think within Singapore it would be the SICC which would be handling those kinds of international adjudications.
Thank you. We've sort of in the last home stretch, as it were, so it seems right that we try and field some questions that are starting to come through. And right at the top of the leaderboard is a question that really touches on the multi-party aspect of construction disputes. In particular, although this is not limited to construction, but the question that has been asked is what would be recommended practice to ensure parties' rights and duties under connected contracts are aligned and to bring them to effective dispute resolution mechanism. So you've got both the pre-dispute, I think, scenario that is being contemplated here, obviously with the object of seeking to avoid problems arising. And if they do arise, then how do you tackle them with an effective dispute resolution mechanism? So I'm going to turn first to Dinesh or Annalise to see, in terms of the dispute resolution side, how do you deal with some of these concerns? And then I'm going to ask William perhaps to think about the pre-contract scenario, because someone like Samsung EPC would obviously be right at the top of the pecking order with a huge number of connected parties to try and deal with. And how would you want to see those interests aligned? Because clearly a dispute is the last thing you want to have, and you want to try and avoid it. So can I just turn to Annalise and Dinesh to see how you feel effective dispute resolution mechanisms might work, and then I'm going to turn to the judge and Lawrence to see what they've got to say about it before I come back to William.
Just a brief comment from me on that is that I think simple is actually better when it comes to dispute resolution clauses generally. And although connected contracts may be complex, I think generally I would think that the solution lies in trying to get the dispute under one form of dispute resolution. So if it's the SICC you want to choose, then let that clause say so and let it be properly reflected in all the subcontracts. And I say that because it sounds like the obvious thing, but I have seen situations where one contract is arbitration and then sometimes another one says something else, because for the reason that sometimes it hasn't been thought through, because at the time of signing, it's always the case, maybe people are not thinking of a dispute. These are the nightmare scenarios that litigators see, but you don't want to see them.
Yeah, well, if you're really unlucky, there's no contract that's been signed at all until the end of the project. But I think picking up on something that the judge said, I think the international community in particular has to think hard about this, because that's where I think the problem is most acute. And in particular, we've seen it through use of experts, where people will game the system a bit to conflict experts out. You may have a discipline where there are very few true experts. But again, when a project is set up, I've never understood why you can't say in the head contract, the first contract, every contract after this must follow this as a dispute. I simply don't understand it, really, apart from the fact that at some level it must mean that these parties who are quite sophisticated don't want that. And I think it's trying to encourage that and to say, for example, if you choose the SICC, you'll end up with quite a very effective, sophisticated, highly qualified judges with things that can be enforced that will actually promote, but also the ability, because again with dispute boards, how many times do contracts have dispute boards in them and they're never appointed until the end? Or one recently where I've been appointed, and asked to wait 2 years before I do anything, which sort of seems a bit self-defeating. So, again, could the SICC fill a role in these big projects whereby they are effectively acting more as a DAB and guiding the parties and ensuring that they speak to each other rather than everyone storing up everything to the end of the project and then you ending up with a multitude of arbitrations, court proceedings, inability to enforce, and that would save cost, time, dispute for everybody.
Perfect segue into sort of the SICC's approach to this, which primarily is what this event is about: multi-party nature of disputes, multi-contract disputes, which is sort of exactly what happens in the construction scenario.
Maybe if I could make a couple of comments, and I don't know whether Lawrence would like to add on something after that. I think the obvious advantage of a court is that in addition to whatever chosen court jurisdiction it may have, it will also have an ability to join parties based on its general jurisdiction. So if a matter comes before the SICC where two parties have chosen the SICC, there is that possibility of joining additional parties so long as they would come under that general jurisdiction, which would include such concepts as necessary and proper parties and so forth. So that gives a court a more, first of all, a longer reach, and secondly, a more secure reach than arbitration, where it all depends on what the two parties have agreed. And so if you have some problem in any of the many arbitration clauses that might have been carefully constructed at the beginning of the transaction, that can put a spanner in the works, and you end up with it not being, not fitting correctly. And in fact, tomorrow I'm talking about interpretation of arbitration clauses in GAR Live at the lunchtime slot. So you want to hear a more elaborate version of what I've just said, you can come and listen to that. We probably have to pay, I don't know, we'll probably take money out of my keynote address or whatever. But I think that I think is a critical point, that with a court you can not just choose it, but have recourse to it from its broader jurisdictional standing.
Thank you.
I will leave that as such.
Okay.
Yes, most certainly. But I think just a reminder of what George earlier said, that for the comments that Annalise has made, we'll most certainly look into it as we refine and improve on the TIC list and other procedures within the SICC for sure.
Thank you. Those trying to attend tomorrow's event where the judge is going to be speaking, probably remind of the adage, there's no such thing as a free lunch. So with that, I'm going to turn to William to try and respond to the question of sort of aligning the interests when you're dealing with parties in a connected contract scenario. And this is sort of pre-contractual dispute. From your perspective, what is the best way of trying to deal with these issues before it all blows up and somebody comes along to wipe the soot off your face?
I actually have an experience to share, and I can't say this is pre-contract, but the reality is usually you don't have a uniform dispute resolution clauses in all the tiers of contracts and subcontracts. But construction projects, infrastructure projects are long life projects. What we did, actually sometimes you need to innovate out of all these limits from the contractual clauses. We did this for one project, actually it's a project in Singapore. And it involves differences between engineering consultant, the main contractor, and a group of subcontractors. And what we did is we formed a steering committee, a multi-party steering committee. So we cannot afford to leave it alone. Works must still proceed. But we actually split it up into different checkpoints at a half-yearly intervals for the parties to come together and sort of look at their differences. But in our role as the general contractor, what we are providing is is sort of a prospect of resolution of the dispute ongoing, but not to pile up everything, all the disputes, and wait for it to blow up at the end of the project. And that has actually worked for us. But really, this is outside of thinking outside of all the contractual clauses and the limits.
Thank you. Thank you so much. We've got 4 minutes left. I'm not sure that that's adequate time to answer this next question that's up on the leaderboard. Will SICC replace arbitration?
And it says specifically question for
Mohan, yes. which of course completely undermines my role as moderator. I'm completely neutral in this. So, I'm just deciding whether I swing the question to my right or whether I swing my question to the left. And in all of 2 minutes that's left, I suspect this is a constant question. And, some part of this is, I think, the question of what the SICC is setting out to do and what it is seeking to redress in terms of the constituency it's trying to deal with. And certainly, I realize, as the judge has pointed out, the question is addressed to me. I'm not quite sure why it's addressed to me in my role as moderator. Perhaps they want a neutral, completely unbiased.
Maybe I should.
So why don't we let the judge speak for SICC?
Maybe I should answer it since it's... So, first of all, of course, SICC is obviously not seeking to replace arbitration. The role of international courts is critical, I think, to the overall health and integrity of any kind of transnational justice, which is what arbitration is a part of. But that doesn't mean it replaces arbitration. It actually undergirds arbitration. But I think there is one other point which comes out in that question, which is that if one is a user considering arbitration versus an international court, then there is one obvious difference, that in an international court such as the SICC, and in the SIC's case in particular, there is there is a right of appeal. And that may be an advantage or it may be a disadvantage to you as the user, and that's for you to evaluate. The obvious advantage is if you lose in first instance, you can go up on appeal and hopefully you get what you think is the right answer in the Court of Appeal. But on the other hand, if you really feel that, well, enough is enough, then one shot in an arbitration may well be the route you want. But that's what you're going to be stuck with, because after that, no matter how ingenious counsel are in terms of trying to squeeze merits appeals into all sorts of other kinds of challenge, that's not going to succeed. So it's so the majority of arbitration awards, which may contain, there's probably a small subset of arbitration awards which have errors, but of those when they do have errors, you're not going to get them corrected because they're going to be immune to a challenge because those relate to the merits.
And that clearly lies at the heart of the question, because the second half of that question, I think, underlines the point that the judge was referring to, because it says especially given that arbitration awards are very limited grounds to set aside. And I think, as the judge said, it really depends on what the parties want. As Annalise has pointed out, there are certain cases where parties said, we just want this matter to be adjudicated, to be resolved, so we can move on. We're not really interested in pursuing it till we get perfection, right? And for those parties, arbitration clearly holds appeal, and in particular, parties who want to try and deal with these sorts of issues beyond the public glare, there are clearly advantages involved. But I think the SICC presents an opportunity for parties who are looking for something a bit different. The SICC doesn't pretend to be arbitration. It is not. But it does deal with a group that is looking for something beyond that. And I think the SICC's initiatives that we've been discussing today shows that they are really, really quite proactive in trying to deal with real concerns that affect the commercial realities of what's going out there. So, they're really, really quite proactive. It's much harder, I think, to try and get this kind of initiative moving in the arbitration world because it's just so decentralized. So, there's a lot to be said for both. We've just come up now to the end of our allotted time. So if you'll forgive me by carrying my rockstar analogy down a little bit further, it's really time to bring the curtains down. We have to bring this to a close. And on behalf of all of you here today, I hope I'm not overreaching my position by extending our collective thanks to our really hardworking panel this afternoon for sharing their insights and their expertise. And may I invite you to show your appreciation in the customary way to our panel.
And of course, much special thanks to Mohan for moderating this session and holding all of us in our respective places.
Oh, you're very welcome. It's an absolute pleasure. Well, thank you very much, everyone. Enjoy the rest of Singapore Convention Week, and it's been a real pleasure having all of you here with us today. Thank you.
Thank you.
Thank you.
Just gonna ask you to
Oh, yeah, sure.
present momentum.
Oh, of course, of course. Do you want to take a picture with them, or am I just to hand it to them? You better come closer. I think we can't take from so far. I just go around, right? Okay. Where's our photographer? Okay, there you go. Thank you. I hope it's worth, I don't know what's in the bag. I hope it's worth a bottle of wine.
It's an expensive bottle of...
Well, no. Okay, thanks so much, William. Thank you.
I did get a memo.
Thank you very much.
And here's the bag of goodies.
Thank you. I look forward to it.
Let's take a picture. Okay, got it. Okay, last one. Dinesh, here you go. Okay, you want a picture? Sure. You should get a picture.
Yeah, definitely. Yes.
Did you mention that the lunch tomorrow is...
Oh, no, that's the GAR lunch. That's the one that the judge...
I know, it's disappeared.